Good afternoon. On behalf of the New York State Science and Technology Law Center here at Syracuse University College of Law, welcome and thank you for being here. We are funded by ITAR and we are happy to present today export control and international trade issues, the International Traffic in Arms Regulations, also known as ITAR. We're very pleased to have Michael Ginsberg and Thomas Lavery, attorneys from the firm Pattison, Sampson, Ginsberg, and Griffin of Troy, New York. The firm serves as outside counsel to RPI, and Mr. Ginsberg is chief external counsel to RPI. We also have Jeffrey Millens, who is the vice president of Transborder Global Freight Systems, as well as Jim Clem, also from Transborder Global Freight Systems, an international and domestic freight forwarder from Latham, New York. So thank you again. We're going to go about an hour, and if your schedules permit, we will continue for 15 minutes after to allow for questions. You may submit questions via email, and they will be read as time permits, but we will probably save the questions till Mr. Ginsberg and Lavery conclude, and then after Mr. Millens. Thank you very much, gentlemen.
Molly, thank you. And on behalf of the panel today, we'd like to thank Molly and the Center for inviting us to speak at this event. My contact information is now on the screen, and I'm sure that everyone has a copy of the PowerPoint presentations. Mr. Lavery's contact information is now on the screen, and our general firm web address is psgglaw.com. Welcome to Export Control and International Trade with a focus on ITAR compliance. When dealing with export control compliance issues, there are a few items which every exporter should know before going in. What is the item? Is the item controlled under the export control laws, which I hope everyone is somewhat familiar with the pervasive nature of them at this juncture. You need to know what the functions are of the item that's being exported, or if it's technology, what the functions of that technology are, the characteristics, and the technical parameters. You need to know where it's going, who's going to receive it, what the end use will be. For instance, the end user may not be the party that's receiving the item being exported. They may be re-exporting it, and if they are re-exporting it to an entity or country that is banned, the original exporter is still on the hook for that, and it constitutes a violation of the export control laws. The best way to manage those issues is to have an export control plan, to comply with that plan, and to do your due diligence. One item associated with performing that due diligence is obtaining letters of assurance. They're basically statements from your foreign trade partners that they will comply with the U.S. export control laws. There are a couple definitions which I think are important here. What's an item? The definition of the item is up on the screen right now. What constitutes an export? These definitions that are on the screen right now are really the definitions under EAR, the Export Administration Regulations. However, they're very similar to the ITAR definitions, which Mr. Lavery will cover in a few moments, or maybe more than a few, but we'll see how it goes. One thing that I think every exporter and everyone engaged in, or anyone who has employees that are foreign nationals needs to be familiar with what a deemed export is. A deemed export is the release of information or technology, source code, to a foreign national on U.S. soil. A deemed export can be or can occur when a conversation is had, when an email is sent. If you leave a item which is regulated up on your laptop and a foreign national comes into your office and views it, it can be viewed as a deemed export by the federal government. Another key issue to be concerned with are dual-use items. These are items which have a military or terrorist application, but were not necessarily created for that purpose. For instance, water or fuel pumps, broadband amplifiers, lasers, GPS systems, those all have dual-use capacities, and you need to make sure that whatever item you're manufacturing and exporting if it's regulated, that you are in compliance with the export control laws. We're going to breeze right through the EAR portion of the PowerPoint presentation since we don't have time to go into it, and because the center has asked us to focus on ITAR compliance. But we thought that it was appropriate for the attendees here to at least see what those items are. So let's just breeze through them. EAR, as I mentioned before, is the Export Administration Regulations. It's administered by the U.S. Department of Commerce. It's enforced by the Department of Commerce, the FBI, and Homeland Security. Here are listings of some of the items which are subject to EAR. They do require licenses unless there's an exclusion. Listings of general prohibitions, things that you cannot do without complying with the licensure requirements under EAR. The EAR penalties are somewhat similar to the penalties associated with ITAR violations, and we'll deal more with the ITAR violations when we get to those, but we thought that it was important to at least identify what the EAR penalties are. There's a denial order, which is similar to the ITAR debarment order, which basically prohibits an exporter from engaging in export or foreign trade transactions. If there's a component of your export or your business which is 30–40% of your sales, and you are prevented from engaging in that activity, many businesses would not be able to withstand that. There are civil fines as well as criminal fines. You can see them on your screen, and up to a 10-year prison term associated with EAR violations. Let's move along to what everybody's here for, ITAR compliance issues. ITAR is the International Traffic in Arms Regulations. It's administered by the U.S. Department of State and enforced by the FBI and Homeland Security. As I just mentioned, one of the penalties for running afoul of the ITAR regulations is debarment, which again prohibits the export of whatever you're exporting. It doesn't necessarily have to be an item, could also be technology, intellectual property, or a service such as military-based training. A ITAR violation, in addition to a debarment order and the financial penalties, which we'll cover in a moment, both the offending items as well as the means of export, being either a vessel, a vehicle, or an aircraft, are subject to seizure and forfeiture by the federal government. The freight forwarders who are engaged in export compliance issues are very focused on this issue. I'm sure Jeff Millens from Transborder Global will address that, because obviously they don't want their vessels or aircraft seized. ITAR violations carry with them some pretty stiff fines and penalties. You've got civil fines of up to $500,000 per violation, together with administrative penalties, which often are greater than the fine itself. You've got criminal fines to the tune of $1 million per violation, and imprisonment of up to 10 years. Unfortunately, it's usually the head of the business who ends up with the prison term. often the president. At this point, I think it would be to everyone's benefit if we could go through a couple case studies here. And when the enforcement officers come, they come in force. This is a photo that I've taken from a news article where a U.S. national was arrested abroad for ITAR violations. Let's talk for a moment about some specific cases. I'm sure most people are familiar with the Blackwater Enterprise. They may not be happy with this characterization, but the mercenaries who were involved in Iraq and Afghanistan. In August of 2010, they entered into a plea agreement with the federal government where they agreed to a $42 million fine, which was associated with weapons exports to Afghanistan, the rendering of proposals to train troops in Sudan, and the engagement in sniper training for Taiwanese police. ITAR violations, and Mr. Lavery will cover this in a little more detail, basically focus on two different areas. There's defense articles, which are items such as the weapons exports in the Blackwater matter, or services associated with ITAR violations, which would have been the sniper training to the Taiwanese police. Another example of ITAR violations was with regard to ITT Corp. They manufacture night vision technology. In 2007, they were hit for $100 million in fines and forfeitures. Additionally, as part of the agreement that they reached with the U.S. government, the U.S. government obtained what's called purchase rights over future developments by ITT, whereby their intellectual property was now basically owned by the U.S. government, and the U.S. government could share that with any defense contractors that they wanted to. That's extremely pervasive, and in a situation where a manufacturer gets hit with something of that nature, they no longer really control or own their own technology. They were banned for transferring their export-controlled night vision technology to foreign countries. Here's another slide of the federal government engaging in export control seizures. It's unrelated to the specific examples that I'm giving, but people tend to get bored with one slide. I know that many manufacturing entities think, well, you know, we're not Blackwater, we're not ITT, we're not ever going to come up on anybody's radar screen. That's completely false. There's an example of that with regard to Elitech Technology Corporation, where in 2006 they exported one industrial furnace to China, which was deemed to be an export violation by the federal government. The penalties and fines there were minimal. They were hit with a $1,500 criminal fine and a $5,000 administrative penalty, $4,000 of which was waived. However, the president of that company went to prison for 1 year and 1 day, which leads me to the conclusion that it was a felony. Otherwise, they would not have been hit for that extra day. Something that I think should ring home with every manufacturer engaging in foreign trade. I'd like to move on now to an example for our freight forwarders. In 2009, DHL was hit for $9.44 million in civil penalties associated with their aiding and abetting illegal exportation of goods to Syria, Iran, and Sudan. Basically, they're a freight forwarder. They're a transportation company. I think most of us are familiar with DHL. They run plenty of ads in this country. One of the other items which was deemed by the federal government to be a violation of the export control laws was their failure to retain airway bills and to maintain appropriate export control documents, in conformance with the regulations. Again, it draws to the necessary and pervasive nature of the export control violations and the federal government's insistence on compliance with those, including record keeping. Let's move along to our next slide. I don't know if anyone's familiar with this gentleman and his case. The slide now before you is a photo of Professor Emeritus at the University of Tennessee, John Reese Roth, who in September of 2009 was convicted of ITAR violations and sentenced to a 4-year prison term. Yes, very heavy-handed, and the federal government came down hard on this guy. Atmospheric Globe Technologies, Inc., a individual company, licensed plasma technology from the University of Tennessee, and they hired John Reese Roth as a technology transfer consultant. The technology which was licensed to them is used in drones, unmanned aircraft. Professor Roth was convicted for assigning several foreign national graduate students to work on the contract that he had entered into with Atmospheric Globe Technologies. They were a Chinese national student and an Iranian national. He was also hit for exporting technical data and defense services by sharing the technology with those two students, and additionally for traveling to China with his research on his laptop. We've heard that Homeland Security is now cracking down at the borders and checking personal data assistants and laptops to see if there are export-controlled items on them. Something that you really need to take seriously when you're traveling. We've heard recommendations that those items be purged from your technology items when you travel. The John Reese Roth case should be of particular concern to colleges and universities that are engaging in shared technology, research technology funding, and technology transfer, even if you are engaging in this research at home here in the States, you can still run afoul of the ITAR and EAR regulations by sharing that information with foreign nationals. And if we recall, we mentioned this previously, they are deemed exports. The items don't have to actually leave this country for there to be a violation. And I'm going to wind up with a case involving the University of Texas, Austin, where one of their professors was in contact with a group of students from Universidad de los Andes in Bogota, Colombia, who had developed a small CubeSat, which is about a $65,000, very minor, not very technically savvy satellite, which they developed. The professor at the University of Texas invited these folks from Colombia to come and test the satellite at their testing facility in Texas before it was actually launched, and the federal government deemed this to be a ITAR violation because he had not obtained licensing to do that previously. There was no large fine associated with it. There was no criminal incarceration, But again, it brings home the point that colleges and universities need to pay particular attention to what they're doing and who they're doing it with, so as not to run afoul of the export control laws. The University of Texas matter was clearly identified as a military-based service being provided to the Bogota, Columbia students. Thank you. I know we rushed through that a little bit, but we are running short on time, at least, or trying to comply with our time restraints, and we wanted to leave some time for Q&A at the end. At this point, I'd like to turn over the presentation to Thomas Lavery from our office.
Good afternoon. I'm going to talk about items that are subject to ITAR. Items that are subject to ITAR, we're talking about defense articles and defense services. A defense article, as you can see from the slide, is an item appearing on the U.S. munitions list, the list that's under Part 121 of ITAR. But a defense article also includes technical data, and under ITAR, technical data means information that's required for the design, development, production, manufacture, assembly, operation, repair, and testing and maintenance and modification of a defense article. That would include blueprints, photographs, other documentation. Technical data may also include classified information relating to defense articles and defense services, information that's covered under an invention secrecy order, which may be issued under the U.S. Patent and Trademark Office, and it may include certain software directly related to a defense article. Now, if you've reviewed the list, let's say you have an item, an article, and you're not sure whether or not it falls under the U.S. munitions list, the actual entity that is charged with regulating defense articles and defense services, the Directorate of Defense Trade Controls, they have a procedure called the Commodity Jurisdiction, or a CJ procedure, where you can electronically file a request, a CJ request, to get the DDTC's determination as to whether your item falls under the munitions list. Now, when we're talking about defense services under ITAR, we're talking about furnishing technical assistance, training, and technical data related to defense items. And we'll talk about the export of those in a little while. So we switch to the next slide. We're talking about licensing requirements. And when you have about 15 minutes to talk about ITAR, you have to burn right through, right to the heart of the matter. And without a license from DDTC or an available license exemption, you cannot export or re-export a defense article. You cannot export or re-export a defense service. Now, what is an export under ITAR? It's defined differently than under the EAR. An export under ITAR includes the sending or taking of a defense article outside of the U.S. in any manner. But there's an express exception to that. Say you have technical data in your mind, okay, it's controlled under ITAR, and you decide you want to take a vacation to some lovely foreign destination. If you go on that vacation outside the country, that's not an export, as long as you keep that technical data to yourself. The export under ITAR also includes things that actually can happen either in the U.S. or outside of the U.S. For example, an export includes transferring a registration, control, or ownership to a foreign person of any aircraft, vessel, or satellite covered by the U.S. munitions list, whether it's in the U.S. or abroad. Now, I use the term foreign person, and you have to know who that is. Under ITAR, a foreign person is anyone who is not a U.S. citizen, not a permanent resident, green card holder, or not a protected individual, meaning persons who are here under political asylum or political refugees. A foreign person also includes foreign companies, foreign organizations, foreign governments. Now, going back to exports under ITAR, an export under ITAR can occur through the disclosure or transfer within the United States any defense article to an embassy or agency or subdivision of a foreign government, and that disclosure can be visual, it can be oral. An export also can occur by the disclosing, whether oral or visual disclosure or by some other means, in some tangible form. A disclosure transferring the technical data to a foreign person, whether in the United States or abroad. And that's ITAR's version of the deemed export that Michael was talking about with respect to the EAR. And finally, an export can occur by performing a defense service on behalf of or for the benefit of a foreign person, whether in the U.S. or abroad. Now, looking at the slide, when we talk about a license, one of the preconditions to getting a license for an export under ITAR is you have to register with the DDTC unless an exemption applies, of course. And it only takes one export. So that's one of the typical preconditions to an export. I want to talk about the concept of re-export because it differs under ITAR from that under the EAR, which was set out in some earlier slides. A re-export or re-transfer under ITAR means the transfer of defense articles or defense services to an end user, or destination not previously authorized by the DDTC. So if you have a switch in end users or end use, that's a re-export under ITAR. So that's something that you have to consider. We move to the next slide. I just want to briefly talk about some common exclusions. The education exclusion, information concerning general scientific, mathematical, or engineering principles commonly taught at universities. That information is excluded because it's expressly excluded from the definition of technical data under ITAR. Moving to the next slide, fundamental research exclusion. That's research information which is published and generally accessible to the public. That exclusion can be lost if the university or its researchers accept restrictions on publication of the research results, or if the research is funded by the U.S. government and imposes certain access or dissemination controls on the research results in the project. So universities have to be on the lookout when they're reviewing their sponsored research contracts for publication restrictions and restrictions with respect to personnel, be it foreign persons, with respect to participation in the project. Moving to the next slide, employment exclusion. Under certain circumstances, technical data may be shared with employees that are foreign nationals. And an example of that under ITAR is a situation that would be applicable to universities. Disclosures of unclassified technical data in the U.S. by a U.S. university to foreign persons who are full-time regular employees of that university is permitted, provided that the employees, they use the term permanent abode, throughout the period of employment is the U.S. The employee is not a national of a country to which exports are prohibited. That essentially refers to embargoed countries, and we want to look at section 126.1 of the ITAR, which talks about certain countries that are subject to embargoes. A lot of the, consists of the usual, Cuba, Sudan, Syria, North Korea. But it also includes other countries like China or other countries that are subject to UN arms embargoes. So that's essentially a brief rundown of some general exclusions, and I think my time has run out.
Thank you, Tom. And so everyone knows, here's our general disclaimer. And Molly, if anybody has a question right now, let's take one question or so. Okay, Molly's telling me there are no questions.
I have a question.
Mr. Millens.
Yes, I have a question. One of the things that we look at with the EAR is for people when they ship under to get an end use certificate so that they understand what the end user of the product is doing and what the final end use is. And we tell them for record keeping, it's a very important thing to put in their records in case they were to get audited, or if their end user eventually did resell that product and they wanted to protect themselves. Is something similar like that in the ITAR, or does it fall right under the EAR?
There are some licenses issued by DDTC would require a certificate like that to be signed by the foreign consignee and the foreign end user. That does exist under ITAR. It's just good practice, quite frankly, because of the definition of the re-export under ITAR. Re-export, occurring because there's a switch in an end user or an end use, that's pretty serious.
As we indicated previously, just because the final end user is not who the exporter intended it to be, doesn't relieve them of liability for an ITAR or EAR violation. At this point, I think we probably ought to turn the presentation over to Mr. Millens.
Well, thank you very much. It's a pleasure to be here. I'd like to say thank you to Molly for having us. Thank you, Michael and Tom. I learned a lot from your presentation, so thank you very much. And thanks to all of you for being there, because it shows the initiative to want to learn and want to get educated. And my role today is to talk about compliance and ITAR from a forwarder perspective and what the forwarder role and responsibility is. And I think from one of the key things for a forwarder is to have a customer who wants to get educated, to get a customer who wants to be informed, and get a customer who wants to understand the situation rather than looking to the forwarder for everything. We are there to assist, but we cannot do everything, and the ultimate responsibility lies with you as the exporter. We will always assist you, and as we say, we will guide you to the water, but we cannot drink the water. So for all of you out there, thank you very much for taking the time out of your day to get more educated and learn more about these issues. And it's pretty hard to keep lawyers and sales guys talking within a time constraint, so that's another interesting part of today. We're going to move forward off that first screen, which kind of tells you a little bit about what we do, import, export, domestic, and all that. And we have our mission statement, which I'm not going to read to you, The basic premise is we're here to help you as a company reach your profitability and efficiency. With that comes compliance. With that comes understanding how to move your cargo. With that comes understanding the laws and the regulations and efficiency. So our goal is a pretty strong goal, and it's to help you be more efficient and profitable as a company. Thanks, Mike. Put a little bit about our timeline. I always believe that when you start potentially doing business with someone, or you're listening to somebody on a webinar, you should know a little bit about where they came from, a little bit of legitimacy. So there's a little timeline on our company. We are 13 years old. We take a lot of pride in what we do and how we do it. At this point, we're up to about 48 people. We have fun, we're committed, and we're stressed out, because that's what the world of freight was all about. The next slide, which is associations and certifications. I put this slide here mainly because I want people to understand what goes into being a forwarder. You can't just start a week down the road and be certified to handle all of these complex issues that are coming your way. There's a tremendous amount of homework that needs to go in it. There's a tremendous amount of research and a lot of paperwork. So these are all of the different associations and certifications that we have as a freight forwarder and customs broker. And when you do business with somebody, whether it's transborder or another freight forwarder, you should understand what is their backbone and what makes them up. So take a look and ask them what they are associated with, what are their certifications, because if they're handling your valuable products to go overseas, you want to make sure that they're the right partner for you. Next screen is just a little bit about me. Not here to go too much into it, other than I've been in this business 17 years. I had the good fortune to start Transborder 13 years ago with 2 other partners. My background was in communications and in sales, and I happened to fall into the forwarding industry. I don't think anybody wakes up as a kid and says, hey, I'm going to go into forwarding. But it's a fantastic industry. It's diverse. It changes every single day, and it's a heck of a lot of fun. What is a freight forwarder? And I got to tell you, it's an interesting question, because when you try to explain it to somebody and you look at this incredibly large definition, they fall asleep on you. What is a freight forwarder? And when you go to parties and everybody goes, well, what do you do? What do you do? And then you say you're a freight forwarder, they look at you like you got 3 heads, because nobody understands what a freight forwarder is. Well, let's simplify it. It's a travel agent for cargo. So our job is to get your cargo, your product, your hard work, your sweat, your ideas from one place to the next place. Now, everybody will say that sounds easy, but that is not easy. There's a lot that goes into it. So you've got this big formal definition, simple. We are a travel agent for cargo. What do? We do export via air and ocean. We do import air and ocean. We do domestic, air, truck, and intermodal. We have a banking department, so hey, what good is a sale until you get paid? And as you go to some of these foreign countries, you would take higher risk, especially in certain parts of the world. You've got Europe, which has one level of risk, and then maybe you have the Middle East, the Far East, South America, South Africa, other parts of the world all have different levels of risk. You want to get paid for a product. Anybody can sell something for nothing. If you don't get paid for your product, it's not a sale. So you want to make sure, and those are all issues that are going to come up. Consulting, we go on site with many customers at no charge to offer consulting on both import, export, domestic, any issues that may be there, banking, and Incoterms. Trade show management, CTPAT certification for importers, insurance, which we're going to talk about, and educating seminars. Anyone can move something from point A to point B, but there's more to it. So anybody can do something for you, but are they doing it the right way? Are they doing it the most cost-effective way? Are they doing it the way that's protecting you as an exporter? There's more to just moving cargo. Incoterms, I got to tell you, this is one of the more confusing things for many of our customers. They don't understand Incoterms. They don't know why they need to use an Incoterm. They don't know where it comes from. But if you have somebody selling your product overseas and they don't understand Incoterms, which stand for International Commercial Terms of Sale, and they define the roles and responsibilities of both the seller and the buyer in the transaction, you are going to have major problems. The Incoterm is the foundation to the entire export sale. So it's like building a house and having a poor foundation. The whole house will fall in. If you do not understand your Incoterms, and all the parties within your company who are dealing with that export transaction do not understand Incoterms, you will have problems, either on a compliance basis, either on a cost basis, because now you're paying for something that you didn't understand you were going to have to pay for. So anybody involved in the process needs to understand Incoterms. That goes from people on the dock, shipping. That goes to finance, which has to reconcile cost. And most importantly, and the hardest place to get people to understand Incoterms, is your sales force. Those who sell your product need to understand how the Incoterm affects you in all of those manners. And unless you as a company take the time to educate all those involved, you will fall into problems. Now, there are books and books and books on Incoterms that if you can't sleep at night will definitely put you to sleep. And you can read them as much as you want, but I have found the easiest way is to look at a chart of responsibility, which we've put together for you here. And what I found interesting with Incoterms is most people feel that they only have to do with freight. Well, freight is part of the Incoterm situation. There are many other services which are listed along the left-hand side of this that deal with the Incoterm. And you can see the S stands for seller, or it actually is written out as seller and buyer, and who is responsible for what and what they have to pay for, from storage to loading charges to duties and taxes. Just as you're going to get comfortable with these Incoterms right now, I want to let you know that at the beginning of 2011, they're all going to change. There's a couple Incoterms leaving. So you need to understand these Incoterms. The important part, too, is they need to be on your documents. They need to be on your commercial invoice. And Incoterms should always be followed by a named place. So, for example, you might have X Works Syracuse, New York. You might have DDU Berlin, Germany. So Incoterm needs to be followed by a named place. One other key factor to understand in regard to Incoterms is they do not define transfer of title and or ownership. So when you sell your product overseas, the Incoterm has nothing to do with who owns the product or when transfer of title or ownership takes place. You need to have that clearly defined in another part of your sales contract. So some people will think, I'm going to sell at X Works for my door location in Syracuse. So I have no more responsibility, and as soon as the customer overseas has their forwarder come in to pick it up, I'm done. I don't own it anymore. That is not true. You need to define in your contract when transfer of title and or ownership takes place. The other issue to take a look at is insurance. Only two Incoterms contain insurance, CIP and CIF. That does not mean that you cannot insure your product. Typically, they're there for letter of credit and or banking reasons that people want to use those terms. But those two Incoterms that have insurance explicitly stated in them, your Incoterm should always be followed by a named place. Everybody who's dealing with an export sale should understand what the Incoterm is, how it affects your company as a whole, and you need to educate your company on Incoterms. They will be changing coming up in 2011, so keep your eye out for that. That leads us to the next thing. Here we go. Insurance. Are you covered? Everybody thinks they're covered until they get something damaged and or destroyed, and then they go looking to see that it's not covered. When you move freight with a freight forwarder, unless you have your own insurance or you take out insurance through that forwarder, you are only covered for limited liabilities with the airlines and the steamship lines. That could be 50 cents a pound. It could be $9 a kilo. It's all different depending upon whether it's import or export or international or domestic. So one of the key issues you have to realize is if you have a product that's worth $500,000 and you're shipping it overseas, there is the potential for that product to get damaged. So how do you pack it? Don't chintz out on your packaging material. How many times is it going to be touched? Think about that. A truck is going to come to your dock, pick it up, bring it to another warehouse. It's going to then go to an airline. It's then going to land and somebody's going to touch it. That package that you're shipping, if you're moving in air freight, is probably going to be touched somewhere between 4 to 6 times. If you move it ocean freight, probably a couple more. Be aware of whether or not you have insurance. You can, as an exporter, get insurance. You can get a rider on your own insurance policy. That's the most cost-effective way to insure your product. But just understand whether or not you have insurance. We talked earlier about the ECCN numbers, so there's a slide. Understand your product and understand that you need to have an export control classification number for your product. Schedule B, do you know what your Schedule B number is? That is your responsibility as the exporter. We will help you, we will guide you, but please understand that you have a Schedule B number for your product. Who are you selling and who are you shipping to? Here's a couple lists you can go through. You can see number 4 is the State Department, the debarred list for ITAR. As a forwarder, we have a responsibility to go through these lists. As the exporter, you need to go through these lists at time of sale. When there's a money transfer, you might get 50% up front. You also need to go through it at time of shipment and at time of payment, final payment. So you need to look at these lists 3 times, not just 1 time, because these lists change every single day. We spoke quickly about payment banking issues. You want to make sure you get paid. You want to understand the payment options. There's a variety of different options. Here they are listed. AES submission, which means that when you send an export out, electronically the information is transmitted to the Department of Commerce. Some companies do that themselves. As a forwarder, we are allowed to do that. I encourage you highly, if you have somebody doing your AES submission, to put together a shipper's letter of instruction in which all the information is included on there. It's backup, it's paperwork. You want to be able to do shipper's letter of instruction. Record keeping. There we go. We spoke briefly about record keeping. It is vital. It's not hard to do, but you have to have your record keeping internally within your organization, from any type of correspondence to overseas, to any type of banking issues, to any type of license request. Have all of your records together and accessible if you were to ever get audited. Tracking and tracing, you want to know where your cargo is at all times. So one thing you want from your forwarders to be have firm tracking and tracing so that you can have full visibility as far as customer service. I'm done. I was given a 3-minute notice 2.5 minutes ago, and I believe I came in and I'm at the question part, and that was very hard. Thanks for your time. If you have any more questions earlier in the presentation, there was my contact information. Just send me a quick email, and I'll be happy to answer them for you.
Molly, at this time, I think I've gotten the signal that we've got a couple questions. Why don't we go ahead and see if we can answer those.
Okay. If you work in an area where ITAR could be applied after the fact, how should you protect yourself? For example, if an employee presents a paper to a conference, either out of the U.S. or in the U.S., where there will be a number of foreign nationals, and in that process the technology becomes ITAR restricted.
Tom, you want to handle that one?
Okay, so if you work in an area where ITAR could be applied after the fact, how should you protect yourself? For example, if an employee presents a paper to a conference, either out of the U.S. or in the U.S., where there will be a number of foreign nationals, and in that process the technology becomes ITAR restricted. Perhaps it means ITAR.
Let me just start by saying that it doesn't become an ITAR issue after the fact. It's either ITAR controlled or it's not. But having stated that, Tom, why don't you address the issue?
That's the key. I mean, it's not going to be ITAR controlled after the fact. It either is or it isn't. It's either something that's controlled under ITAR or it's not. I guess I don't really understand the question. I don't think it's something that really would occur
In
Would
this,
it be in the exception?
in this instance, there might be a fundamental research exception, which therefore you would fall into, and you wouldn't run afoul of the ITAR compliance requirements.
Perhaps.
Real quick too is that when you deal with compliance issues with the government, the answer of I didn't know or I was unaware is not an acceptable response. The government, when you become an exporter of a product and or service and or knowledge, the government expects that you are taking the appropriate actions up front to understand the rules and regulations that you're now getting involved in. So by saying I didn't know that or I was unaware of that does not absolve you of any blame or situations that could arise because you do not follow.
Yeah, in that instance with the atmospheric low technologies,
Professor
say you
Roth.
have a professor is
Right.
going to a conference and has a technology that might be something, how would they find out first whether or not they needed to be concerned about creating a deemed export if they know there's going to be foreign nationals in the audience?
Well, they have to know what the technology is, and they're going to have to check the list to determine whether it would constitute a defense article before the fact. Sometimes, depending on the context that you're talking about, sometimes, like in situations with non-disclosure agreements, let's say, where you anticipate a meeting exchanging confidential information, you might want to put in the non-disclosure agreement a provision that says that if you are going to be provided export-controlled information, you have to be notified beforehand. You have to be notified of the ECCN number or ITAR designations before that is transmitted, so that you're not in a situation where you're being surprised with this information. So I think you have to be careful about those issues, and those issues can be addressed at an earlier stage so that it's not a surprise.
Export control compliance is a very difficult area of the law to navigate, and we would recommend that they consult with their legal professionals in trying to navigate through those regulations. Once the export control plan is in place, it's a lot easier to manage it internally. But you've got to figure out whether or not you fall within a regulated item. The federal government's current posture is to shoot first and convict later. And they are coming down heavy-handed on everyone these days, in spite of the Obama administration's deliberate attempt to increase exports twofold over the next 5 years.
Here's another. Regarding exports, what about bringing a laptop with defense information on the drive to a foreign meeting?
As long as you don't share it with them in the car, you're okay.
Right.
Yeah, you can't give access to that information to the foreign nationals. If it's on your laptop, it's in this country, and nobody sees it, you should be fine. Once it's disseminated, then you've got a transfer of that technology.
Right.
What about with traveling? Did you say that people should be concerned about the information being on a laptop when they're traveling
Absolutely.
to another country?
Absolutely, and that was one of the items that Professor Roth got banged for. He had his technology and information on his laptop when he went to China.
Do you have any experience with the United States Commission? I believe it's the United States Commission that helps people who are trying to export goods.
Well, I think what they're referring to is the Commerce Department. And the U.S. Commerce Department, one of its main goals, and I know we've got an attendee from the Commerce Department, one of their main goals is to aid folks with exporting. They won't help you navigate through the legal structure, but the Commerce